please mute your phone or your computer so that it doesn't have any unnecessary feedback. And in order to establish a quorum, I will verbally call the roll of our members. You'll let me know that you are here so we can establish that we do indeed have a quorum. We'll do that first. So Ms. Davis.
Here.
Ms. Carpenet.
Here.
Ms. Pepper.
Here.
Mr. Lawless.
Here.
And I'm David Taylor, also present. And so that does establish a quorum. And so we will officially call the meeting to order with a quorum. And then in order to proceed with the meeting, I will make a motion that because the meeting agenda constitutes official business of this body, and that the meeting is electronically, to meet electronically is necessary in order to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 epidemic, that this board will allow this meeting to take place electronically as allowed by the governor's decree.
Second.
Have a motion, have a second. Any discussion? I will call the roll, and if you will answer in the affirmative if you're in favor of the motion, and negative if you are opposed to the motion. Ms. Davis.
Affirmative.
Ms. Carpenet.
Affirmative.
Mr. Pepper.
Affirmative.
Mr. Lawless.
Affirmative.
And I will vote yay also, so that motion passes. We are able to have our meeting electronically, and I will turn this over to Ms. Lamb to conduct our beginning of the meeting ritual.
Hey, Chairman Taylor, this is Quan Poole from Metro Legal. I just wanted to jump in. That test run worked perfectly, but perhaps for the future motions, so that way we can make sure it's recorded, instead of having, so that way people don't speak over each other. If someone wants to second, I think it would work a little bit easier if they would raise their hand, and then you can call upon them, and then they can announce if they want a second, and that hopefully will prevent everyone from, jumping in all at once to maybe second something. But
that's a good, and I just jumped in front of you, Quan, I apologize, but that's a good point, because it also will make sure that we have, for the record, officially who seconded that motion. I believe, was that Mr. Pepper that seconded the?
No, actually it was Lawless.
Mr. Lawless. I knew it was one of the two of you. It was 50-50 guess. So, all right. So for the record, that was Tom Lawless that seconded that motion. And on future motions, if you would hit the raise your hand button. All right. Ms. Lamb.
All right. Thank you, Mr. Chairman. As you just established the quorum and y'all took a vote to proceed electronically pursuant to the governor's executive order number 16, the Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of April 2nd, 2020. For members of the public who may be listening or watching, my name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. We are convened electronically, as I said, pursuant to Governor Lee's executive order number 16, in order to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak, and still conduct essential business of the metropolitan government. Before we move on, well, I'm sorry, we already had the motion to proceed electronically, so we're ready to go as far as that is concerned. In order to convene this meeting pursuant to that executive order, board members are participating remotely, and we encourage members of the public to submit comments in support or opposition to the board electronically at bza@nashville.gov by emailing those comments. We extended the deadline to submit comments, and any comments received by 12 noon yesterday, Wednesday, April 1st, were provided to the board for consideration prior to the hearing. Any comments received after 12 noon yesterday will be read into the record. I'm here at the Sunny West Conference Room at a station that has been set up for anyone who wishes to address the board. Additionally, I've got John Michael, Zoning Administrator, here, and social distance measures have been implemented. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearing. In today's hearings, I will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, if anyone is here wishing to speak in support of the appeal, they may do so. If any opposition is present, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes per presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate telephonically and will then take a vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, and because the board is hearing these cases telephonically, it is imperative that anyone addressing the board come forward to the podium up there in front of me here at the Sunny West Conference Room and speak into the microphone that is at that podium. I would also note that there's some hand sanitizer at the podium, so if anybody wants to use that, by all means, please do so. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum that has been so established. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied, and a permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have several preliminary announcements regarding deferrals and withdrawals, so I will go through those slowly so everybody can mark their dockets accordingly. First, case 2019-300 has been deferred to May 7th. Case 2020-038 has been deferred to April 16th. Case 2020-049 has been deferred to April 16th. Case 2020-057 has been withdrawn. Case 2020-057. That was 2020-057. I feel like I just said 2019. 2020-057 has been withdrawn. 2020-058 has been withdrawn. 2020-061 has been deferred to April 16. 2020-066 has been deferred to April 16. 2020-071 has been deferred to May 21st. 2020-072 has been deferred to April 16. 2020-073 has been deferred to May 7. 2020-075 has been deferred to May 7. And finally, 2020-079 has been deferred to April 16th. Does anybody need me to repeat those? If so, you can raise your hand, and Mr. Chairman, you can call on them for that.
Seeing none.
All right, seeing none. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. The consent agenda for today's meeting was published on March 30th, 2020, so anyone wishing to pull an item from consent could do so electronically. We did not receive any requests to pull anything from the previously published consent agenda. However, as previously stated, we're here at a station set up in the Sunny West Conference Room for anyone wishing to appear in person to pull an item from the consent agenda. We will enter into the record those cases that have been recommended for the consent agenda, and if anyone is here in opposition to one of the cases identified for the consent agenda, we'll remove the case from the consent and hear it in its regular order. First case recommended for consent agenda is case 2020-052 involving property at 1009 Dickerson Pike. This is would be approved with the condition that the appellant would work with Metro Public Works to construct a parking bump out that will remain until Metro reclaims the use for any proposed future mass transit. However, if MDHA, Public Works, or the state of Tennessee does not allow the parking to be built, the BZA approval would remain. Is there anyone here in opposition to case 2020-052? Seeing none, the next case recommended for consent is case 2020-070 involving property at 1005 Southside Avenue. This is a request for a lot size variance to construct 2 single-family homes. Is there anyone here in opposition to case 070? Seeing none, case 2020-074 involving property at 4100B Hembark Drive. This is a request for a setback variance to construct a covered patio. Is there anyone here in opposition to case 074? Seeing none, next case 2020-077 involving property at 42 Shepherd Street. This is a request for a sidewalk variance to construct 2 single-family residences. The application would be approved with the condition that the applicant would build a sidewalk on the Shepherd Street frontage. Is there anyone here in opposition to case 077? Seeing none, case 2020-084. This is a request for a variance from floor area ratio restrictions and a change to a legally non-conforming structure. The this approval would be conditioned on expiration 1 year from the date of entry of the order. Is there anyone here in opposition to case 084? Seeing none, to review, Mr. Chairman, the consent items are 2020-052, 2020-070, 2020-074, 2020-077, and 2020-084. We would solicit a vote from the board at this time regarding the consent agenda.
There's a motion for the consent agenda. It looks like Mr. Lawless has his hand. Is that a second?
Yes, it is.
That's a second from Mr. Lawless. Any other discussion? Seeing none, I will call the roll for approval of the consent agenda. Ms. Davis.
I approve.
Ms. Carpenter. Ms. Carpenter, did I?
Sorry, David, I'm in favor. I hit the button wrong.
No worries.
Sorry about that.
Mr. Pepper?
I vote in favor.
And Mr. Lawless?
In favor.
And I vote in favor also. That motion passes unanimously. The consent agenda is approved.
Members of the public who are here for your cases on a consent agenda, you may go. Please give our office staff until Monday to process the necessary documents. Good luck with your project. Thank you for coming and socially distancing while you sat through those announcements. At this point, we generally call on council members. No one is here, Mr. Chairman. There are no council members. So absent any other announcements, we're ready to proceed with the 2 cases to be heard today.
All right, first case.
The first case is case 2020-084, and you will have to give me a minute to get through these slides.
8-2, which is you. Yeah. Yes. No, there should be a sticker. Is it on?
Does the button, so it is on. I don't have to. Green.
So we are here now on case 2020, not 084, 082. This is a request for a sidewalk variance to construct 3 single-family residences. And rather than building sidewalks, they are requesting to contribute to the sidewalk fund. Before you is a zoning map, it should be on your screen right now, showing the zoning of the property is OR 20.
Yeah, and we don't see that.
Y'all don't see the presentation?
No, we did earlier, but I don't see it now. If anybody sees it, just hit the raise your hand button. Yeah, it doesn't appear that anybody sees the presentation.
All right, give us 1 second. IT is here and they'll see if they can fix that. Can y'all see the presentation now?
No. If anybody can see it, just hit the raise your hand button, but I can't see it.
Mr. Chairman, we're trying to get this presentation shared with y'all. Sounds like it was showing up on your screens earlier, but it's not now. ICS is here trying to fix that, but I will get the board. If you want to go ahead and proceed without it, I can still give you the information. You just won't have the photos to consider, but you have all the documents that the applicant submitted. He has said that he's willing to proceed without the presentation if that's how you want to handle it.
Is there anybody, any of our board members that doesn't have access to the electronic presentation that is presented? If you need that, raise your hand or make a comment. Otherwise, then I think it's fine to proceed. Anyone need the visual? Okay, I don't see anybody raising their hand, so we can proceed.
Okay, so I'll just give you all the facts of the presentation in front of you. The property is zoned OR 20. This is a request to construct 3 single-family residences. As I said, the applicant is requesting to contribute into the sidewalk fund. They're currently not eligible to do that, and they're requesting that variance. Site plan should be, the site plan should be in your board packet that you received on Tuesday, as well as the photographs from a recent site visit that we took of the surrounding property. So if that would be helpful for you to consider, that should be before you, in front of you now, what we emailed you earlier this week. There is no opposition present here. So Mr. Cushman, you'll have 5 minutes to address the board. Please be sure to identify yourself by name and address.
Okay.
And we've got Jessica Shepard here keeping the clock for us.
If you state your name and address and tell us your situation.
Yes, can you guys hear me? I just tried to hit the button here.
We can.
Okay. Rob Cushman, 1019 Avery Trace Circle in Hendersonville. I am working on a project at 421 Veritas. What we're looking to build is 3 stacked flats condo units that are smaller than our normal. Normally we do HPR side by sides. This is an area that would allow us to build 3 by right. If we were to build 2, we would be allowed to contribute into the in lieu of fund. By picking it up and building a 3rd unit, that has taken us out of the running to be able to do so by right. My request is to be able to pay into the in lieu of fund. There aren't any existing sidewalks on the block, and the challenge for me, understanding that that money is not a factor that we can be granted a variance based on. The challenges with these ones for me is when we go and we get a civil engineer to engineer sidewalks, we can be told that we need to take the stormwater really an indefinite distance down the street, and it's a challenge for me to come up with viability of a project when I don't know what parameters I may be operating under. So what could happen with my civil engineers, they may say, hey, you've got to connect this with Nolensville, which is several hundred feet down, and in order to get that information, we spend several $1,000s in several months. So coming to the board, again, my request being pay in lieu for 3 units. This would allow me to build 3, they're about 1,500 square foot flats that would sell at a price point that would be, to me, more reasonable for the area. It's kind of an area of town that is popping like everywhere. And so really, I'd like to be able to offer, particularly with everything going on in the world, things in the lower 300,000 price point as opposed to pushing in the mid 4s and just building what we always build. It's an opportunity to build a product that I couldn't do otherwise. And so having to build the sidewalks would preclude me from doing 3, and therefore I would just go back and probably re-engineer and build 2 units as HPRs. That's the end of my presentation.
Mr. Cushman, this is David Taylor. I have a question for you.
Yes.
It looks like that the land on the property in question is fairly flat, but the land on the left and the right, the 2 homes on the left and the right, have one of those kind of ditches for drainage.
Yes, that is correct. And we actually have a culvert that runs the distance of our property. The challenge is if we submit to stormwater, if we do a grading plan, what they call a sidewalk grading plan, the engineer will go up and down the street, the entire drainage, and make us bring up to current code the area from my lot downstream to the point of nearest connection, usually. And so what that does is that'll preclude me from using the existing culvert, which is in really good shape. It currently runs the entire length of my my frontage, and it does serve the ditch on both sides of my property.
And you're adding, it looked like somewhere between 5 and 7 parking spaces in the front of the property?
Yes, we would be looking to add 7 parking spaces. So with this zoning, with that OR zoning, we could either rent these as, you'd either sell them as single families, we could rent them as long-term, or we could do office rentals. So we've set the units up so they could be any of those things. And so that parking does serve all those uses.
Okay. Are there any other questions from the board? If so, raise your hand. I do have one question for the zoning for the staff, and I don't know if this is for the zoning administrator or for Emily. That, you know, can you help the board understand? I think it's already been through the process of the waiver process, and is there any information to share with the board on why that waiver process was denied and why we're hearing the case today?
So I'll let the zoning administrator answer the reason for why it was denied. The process, the law requires a waiver request be submitted first, so that waivers can be granted administratively by the zoning administrator in consultation with multiple other departments. If that waiver request was denied, as it apparently was here, then the property owner or developer has the right to file for a variance request by the answer questions with respect to his thought process and the reason for denying the waiver request.
Okay. Yeah, and I know the planning department had recommended disapproval and build a code, and then we heard from the applicant about the hardships that he's testifying to that relate to that. Mr. Chrisman, did you have anything else to add?
I don't think he heard you.
Sorry, Mr. Taylor. We were struggling with the dueling mute buttons here. Mr. Michael, the zoning administrator,
Okay.
You've got it right. It's a collaborative process, of course. It involves input from public works, stormwater, planning, and of course us in zoning. Ultimately, the decision that was rendered was based in part on that shared input. Here, to be perfectly frank, there are probably multiple ways that we could go in terms of the best outcome in the field. I think you, with one of your questions, identified what to me was one of the key factors, and that is while we're only looking at the 421 property at this location, the reality is that the properties on either side had certain unique topographical challenges. Mr. Cushman made reference to the culvert that they had installed or were installing with regard to water management issues. The way that we landed on the decision on, and I shouldn't say we, the way that I landed on the decision that I did as a zoning administrator was based largely on the input from the other groups. And I believe we even had some input from the district council member who has been consistent to his credit in pushing for sidewalks. Here, I think you do have at the worst an arguable hardship, at best a pretty solid argument for a hardship. The board is probably in a better position than the zoning administrator with regard to their ability to determine that there is such a hardship that makes the payment to the fund a tenable outcome compared to strict compliance with the zoning code and the sidewalk requirements at this location, which I think were the local street standard of 5-foot sidewalk, 4-foot planter strip, I believe. Given the unique topography on the adjoining lots, you may have a better process or a better path forward to that relief in this instance than we did at the waiver process. Naturally, so any questions?
Is that so? I take it that is a an acknowledgement that I mean, you don't have a strong objection if the board were to, based on the testimony today, to allow payment of the in lieu fee.
I recognize the viability of the argument advanced by the appellant here. And just to be perfectly frank, I like to think that I, like my predecessor before me, if I need to stand on a table and jump up and down and scream about a case, dear God, you guys don't screw this up, I'm willing to tell you that. This is not that case. It could be argued either way. We think we landed on a reasonable outcome, but we are quick to defer to the board's legal right to alter that outcome and reach a different conclusion.
Okay, thank you. Are there any questions from board members or anybody present? I don't see any hands raised. Are there?
Mr. Chairman, I will just say for the knowledge of the board, I did step outside into the lobby as well as outside the building to make sure there was not anyone here in support of or opposition to this case. There was no one present, so unless you have questions for the applicant, there's no one here else who needs to address the board.
Okay. I don't see any hands raised. I don't see any questions. Mr. Chrisman, did you have anything else to say?
I think just the last reiteration is really if we were building 2 units, which you could do by right, we would be granted the ability by right to pay in lieu of. So by asking for the 3rd unit, again, the goal being to build smaller, more affordable units, we can't. I guess that's my final thought.
Okay. Thank you. With that, I will close the public hearing and ask for the board's discussion on this matter. And if you wish to speak, please raise your hand. So thoughts, please. Carbonet.
I will be willing to make a motion, and if anyone would second it, then we could discuss after. But I will move to approve the variance request to pay into the in lieu fund based on the difficulties of connecting the existing drainage ditch to the stormwater system.
There's a motion. Is there a second? I'll second that motion. There is a motion on the table and there's a second to allow the variance and to pay it in lieu as a requirement. Mr. Lawless.
Excuse me, I'm hitting the buttons. There's no 8-year-old in my house right now. I'm going to move the question.
All right. Any other comments or thoughts? Then, Mr. Pepper.
So I want to try to, and it's harder for me not being there in person, but I want to try to understand this hardship and why it's not just strictly a financial hardship, because it seems to me like it could be argued that that's what it is. And I understand the circumstance the applicant is describing, but and I haven't. I'm trying to make my mind up on this, to be direct. So why is it not just a financial hardship?
Okay. Ms. Davis, did you have a comment to that or another thought?
I actually have the same question as Mr. Pepper. As I was listening to the arguments, I didn't hear really other than a financial hardship. I'm also trying to make up my mind, but I heard a lot about a financial hardship and sort of what their right would be if they were building two, but they're not. And so I sort of feel like the law is what it is. You're proposing something that you don't have a legal right to do. And so I guess I'm still listening and I'm still sort of deciding in my mind, but I basically have the same question as Mr. Pepper.
Ms. Carpenter.
Well, my thought on it was that the applicant is willing to pay into the in lieu fund. And so that is making a financial contribution. But I understand all the points that were made.
Well, and I tend to support that mainly because of the ditches on either side of the property. And I've always had a little bit of a problem with the jogs where we require folks to kind of pull the sidewalk back 4 feet of grass strip or 5 feet instead of 2, and you have this little zigzag pattern. I think that bothered some of us when this law first passed, and now we've seen enough of them to know, well, that's just how it works, and little by little these things will come into compliance. But the sidewalks that kind of dump off into a drainage ditch, to me, just have some safety issues, and I just haven't seen one implemented in a way that gives me a lot of confidence that in situations like this street, it feels to me like it is an appropriate alternative to, say, pay the in lieu fee, and I absolutely think they should pay if they're not going to build. Although I do respect the thought and the argument of, isn't this only because they're trying to put a third unit here? I think if they were going to do 2 units, they would pay the in lieu fee rather than build because of the conditions that were described. And so, I don't have a problem with the motion, obviously, since I seconded it, but I don't have a problem with it just because of those reasons. And that may or may not be enough to sway others, because I see their point too. Other thoughts? All right, absent of any other additional comments, does anyone object to taking a vote and having the question called, as Mr. Lawless suggested a minute ago? All right, we will have a vote. I will start with Ms. Carpenter.
In favor.
Mr. Pepper?
Opposed?
Mr. Lawless?
Opposed.
Ms. Davis?
Opposed.
And I will vote in favor, so that motion fails 3 votes to 2. And by our rule, and Emily, do we need to take I mean, I think that we're going to get the same spread on a denial, and the denial actually is, if we don't get a 4th vote within 30 days, then it is by rule denied. And so it seems like we wouldn't need to make that additional motion, but would just need to keep this on the books for 30 days.
Yeah, I don't think you have to make another motion. Certainly you can if you want to, but I don't think it's necessary. It will stay, it will be automatically deferred to the next meeting. As you said, there are 30 days. It's by operation of law. If no vote carries for, or no motion rather carries for affirmative vote, that would be deemed denied by operation of law. So the case will stay on the docket for the next meeting. And if anybody watches the video again or revisits the board packet, we can take another vote at the next meeting.
Okay, great. Thank you. We'll have the next case.
All right, the next case is case 2019-087. This is involving property at 1903 Cephas Street. I think I'm pronouncing that correctly. The applicant is actually not here. I have stepped outside and into the lobby as well as outside of the building to make sure she was not waiting out there. I did not see her here, did not see anyone else here. As the board is often apt to do, it may be appropriate to defer this case, especially under the circumstances, to the next meeting to give her an opportunity to appear. I will say we received a letter from the council member on this particular case in opposition. I'm going to read that into the record. This will be part of your board packet, but because he submitted it today, I feel like we should read it into the record. It says, "Dear Chair Taylor and members, I respectfully request that the Board of Zoning Appeals disapprove the above appeal case 2020-087, located at 1903 Cephas Street, requesting a variance from lot size requirements in the R6 UZO district to construct a single-family residence on the lot. I have received several calls and have talked with my constituents, and they are not in favor of this request. Therefore, I cannot support this variance. Thank you for your service to the City of Nashville, and thank you for your consideration in opposing this case. Sincerely, Councilmember Brandon Taylor, District 21. So we will include this in the board's packet for the next meeting if you choose to defer the case. So at that point, I don't have anything else to say. It's Mr. Chairman, you can take over from here and decide how the board wants to proceed.
Mr. Pepper.
Yes, Ms. Lamb, will that letter that the councilman submitted today, the council person, will that be given to the applicant in advance of the next meeting, or was it copied on the applicant?
We can. We can reach out to the applicant and let her know that the council member has expressed opposition, send her the letter if she'd like to see it, and then if she wants to contact the council person, she would certainly have time to do that.
Okay, I think that would be appropriate.
Yeah, and I will say just we had one lot size variance that was on the consent agenda. This one was not. And just to remind the public and the board, when Ms. Lamb and I review the consent agenda, I only put a lot size variance on the consent agenda if it is under, a very small percentage, say 3 to 5%, and it allows the property owner the same rights as his or her neighbors, meaning that an overwhelming majority of the street or the block or the neighborhood has that right, but this lot doesn't because of either some type of odd shape of the lot or perhaps a survey error or, they're 49 feet instead of 50 and everybody else is 50 foot width, that type of thing. And this case was a case where this applicant did not meet that that kind of criteria that I have. So that's why I felt like it needed to be heard. So Mr. Lawless, you had your hand up.
I'm going to make a motion we defer it.
Have a motion to defer. Is there a second to that motion?
Mr. Chairman, if we could get a specific date for that motion so that we know what docket to put it on.
Would that be to the next meeting, Tom?
I almost want to say to the May meeting, but yeah, next meeting. That'd be the 16th?
Yeah, to April 16th.
April 16th, yeah.
Is there a second to that motion? Ms. Carpenter?
I'll second.
We have a motion. We have a second. I'll do a roll call. All in favor, Tom Lawless?
Aye.
Ms. Davis?
I support it.
Ms. Carpenter?
In favor.
Mr. Pepper?
In favor.
All right, I will vote in favor also, so that passes unanimously, and that case will be deferred until April 16th.
And
Maybe a long meeting.
Mr. Chairman and board members, that concludes the first historic telephonic BZA meeting of the Metropolitan Government of Nashville and Davidson County.
All right, we are adjourned, and thanks everybody for attending this way. Much appreciated. Stay safe.
Thank you all.
Everybody stay safe.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.